Good morning. Happy Friday. I get to, I spent $500 so I could spend all day listening to various classes, people rambling on about nonsense for my MCLE requirements. I don't know if you could tell, but I'm super enthusiastic about it. I would much rather be making money today than spending money today. What are you going to do, though? Today's a big day for our boy, Sergeant Interlied. He gets to smack down the forces of tyranny in his county who are trying to hold him down with a very poorly written and poorly thought out petition for a temporary restraining order, where the only restrained party, or the only protected party, I should say, after Patty Roth and his wife, Selena, and the brother, whoever the hell the brother is, after their names were scratched out, presumably by the mother, as additional protected parties. Now it's only the mother. And so the mother's only able to claim the stalking incidences against her. And yet she's not. And amazingly enough, in her petition, she didn't mention the attempt that she made with her vehicle to either frighten or injure Sergeant Interlied. She rolled up on him. He wasn't stalking her. She rolled up on him. Fancy that. Oh my God, he was outside of a motel or a hotel. Yeah, it's a hotel or a motel. That's not stalking, lady. That's somebody being outside of a hotel or a motel. I mean, your business is to attract the public there, right? Dummy. Anyway, I have high hopes for the good sergeant that he will prevail in his upcoming hearing. That's today, I believe, unless I'm horribly mistaken. So good luck, Sergeant Interlied. Fancy enough that News Now Library has been hanging out in my Discord. Everybody's welcome, even retards like Library. But he has expressed his support, ironically enough, for Sergeant Interlied after I pointed out that our good friend Library, who has had multiple temporary protective orders issued against him. I don't know if any of them were sustained. I don't remember right now, and I don't want to misspeak, so maybe there were some that were. I don't think so, though. I don't remember. Anyway, let's just stick with temporary restraining orders. He has, Library has bemoaned the ease at which they are acquired. And after I reminded him of that, suddenly he is on Sergeant Interlied's side. So there you go, Patty Roth. I'm converting your friends. Even if they do blow you every night to sleep. Because, yeah, I'll go ahead and say it. I firmly believe that Library is gay for Patty. Or, yeah, I mean, Patty may be gay, but I firmly believe that Library wants to suckle the man meat of Patty. My gaydar's going off on that. Anyway, back to the point. Still going rounds in the comments with Two Truth for Liberty. I don't know if you remember the saga. He said the Sixth Amendment says you could have counsel, and that doesn't necessarily mean an attorney. I said no, and I cited Wheat v. U.S., where it says specifically that it has to be a licensed attorney, bar member, whatever you want to call him. All right. And then he switched. He said, "Whoa, obviously I misspoke. I meant the Seventh Amendment." And I said the Seventh Amendment guarantees you the right to a jury trial in a civil suit, in a federal civil suit exceeding $20. And bada boom, bada bing. That's where it went stupid, because then he said that there's some implied. He quoted Lewis v. U.S., but he didn't cite actual language from it that would indicate that there is actually an implication of a right to a non-bar member attorney to represent you. It was very generic text, so I didn't really pay much attention, because it doesn't say what he needs it to say. And then he went on to quote Texas law, and Texas does allow what's called a next friend to bring a suit for you. I haven't confirmed whether or not it allows a non-bar member to represent the incapacitated person who has yet to have a guardian appointed. Every instance I've seen in Texas so far, doing just a cursory search at about 10 o'clock at night while I'm laying in bed on my cell phone, everything I've seen is it has been related to like a next friend is basically like a common law version of a guardian. So you don't have to wait for the court system to appoint somebody. It's a faster, simpler process to get somebody who can bring suit in your name. And I can see the usefulness of it. Like if you're incapacitated and dying, you may want to not wait until a court assigns you a guardian. He keeps telling me, oh, get family law out of your mind. It's actually probate. But what do I know? I'm just a family law attorney. Yeah, guardians are probate. I don't know if that's necessarily family law, but California distinguishes it and Texas distinguishes it. So what do I know, right? It's in the probate code. Anyway, there are no next friends that I'm aware of in California. I haven't looked for it, but I've never seen it. I figured I would have. It's a vestigial thing that is not available in all states. But anyway, my point is that if Texas is making it, then it's not based on the 7th Amendment. It's based on Texas law. So he started up again, and even after my video yesterday where I'm pointing out how stupid he is and how ignorant he is, he started it up again. Because obviously I just don't know. And he has rebutted me, he says, with this Lewis v. U.S. So I'm like, fine, I guess I'll read it. The quoted language doesn't say what he needs it to say, but he's retarded, so he might be quoting the wrong portion, right? That's always a possibility. And I hate doing research for soft-sits, but whatever. It's kind of fun to have debates with stupid people every once in a while. And lo and behold, Lewis v. U.S. is a 6th Amendment case. So we're right back to the very amendment that he said that he misspoke. And he was looking at the 7th Amendment, but he's quoting a 6th Amendment case. And in Lewis, they quote, but they don't actually quote, but they refer to Wheat v. U.S. They actually put the citation to Wheat v. U.S. in there. And it states, the court very clearly states, that there is no right to a non-licensed attorney. So we'll see where that goes today. I can only assume that it's going to be more tap dancing, more idiocy. He has failed his premise, but I'm sure he'll switch to something new and try to tap dance further. I am, however, resolute that there is no constitutional right to have an unlicensed attorney represent you. A state may create a right in certain circumstances. Actually, they may create a right, period, because that's within the state's policing power. Or a federal court may grant you the right to represent somebody as a non-attorney in certain federal courts. So there you go. That's my argument, and I'm sticking to it. I have, however, picked up another sovereign citizen, Rogue Nation, who is equally incompetent. He wants to play word games. His first one is that sometimes shall equals may. And he desperately wants me to talk about it. And I figure, what the hell? I'll show how stupid he is, because I could do it without even researching it. If a law says the court shall grant X, Y, or Z, and the court is sitting in equity, the court may find a reason not to. And you're going to say, well, it says shall. Absolutely it does. But if the court is sitting in equity, then it has the capacity to make a determination based on justice. If the court is sitting in law, like, so if it's in equity, that means that the judge is acting as like the judge and the jury. If it's sitting in law, then there's typically a jury there. And it's not a court of equity at that point, because you don't want jurors making decisions in the interest of greater justice, because they don't understand the interplay between the laws and the goals of the laws, and et cetera, et cetera. You want what we call learned men making those decisions. So, and if you think that people, that jurors are smarter than that, I'm going to refer you to Two Truth for Liberty and Rogue Nation as examples of why they're not. But take, for example, another instance. If the court, or if there's a law that says Bob shall go to the store every Tuesday. Well, that's mandatory, right? Bob has to go to the store every Tuesday. And then what if that same legislature writes another law and passes it that says no one may go to the store on Tuesday? Well, now we have what's called a conundrum, and that's going to get litigated. And so is the first shall, does it mean anything other than shall? No, it means shall. But the court's going to determine which of those two laws has priority over the other. And so that shall maybe not mean shall when it's raining. Or it might still mean shall when it's raining. Who knows? But yeah, this isn't rocket science. These are rules, and the courts have to interpret the rules. Another fun thing that Rogue Nation is doing is he's trying to play that, is this a civil right, or is it a natural right, or is it an unalienable right? Is it a God-given right? Oh, all these terms. They are, whatever appellation you try to place upon them, they are laws. Fundamentally speaking, they are laws. They are legal rights. The Bill of Rights are legal rights. And they may be taken away from you. So they're certainly not inalienable. And they're not natural. You know they're not natural because not every country has adopted them. In fact, many countries have not. And I guess you could say that they are civil rights under some definitions of civil rights, but it doesn't really matter what you call them. What matters is what they are. A rose by any other name would smell as sweet. They're just rights. They're legal rights. If you have someone trying to play that game, then they're retarded. If you have someone trying to say inalienable rights, they're actually quoting from the Declaration of Independence, which I have stated previously is not law. Now, another fun line of questioning that Rogue Nation did is he also jumped on the non-licensed attorneys can represent people in court bandwagon, because soft-sits really want that. They need that because they want to be able to sell their particular brand of idiocy and get paid to do it. And again, I started off with Wheat v. U.S. And then he counters with yes, but what is the actual meaning of the Constitution? Is it what the framers intended, or is it what the court decided in 1988? And obviously it's what the court decided in 1988. And this is why I have such an easy time with these idiots. The very first case that I learned in law school that we discussed was Marbury v. Madison. Marbury v. Madison was like in 1800. or no, it was just after 1800. It was like 15 years after the framing of the Constitution, or after the ratification of the Constitution. So 1803, math is hard, it's early. 88 and 10 would be 98, and 5 would be 80. Yeah, it would be 03, 1803. So it was decided in 1803, and the Supreme Court decided that it had the power to determine the Constitution. Prior to that, it was unknown who had that power. And the Supreme Court just said, look, this is only going to make sense if the Supreme Court gets to be the ultimate arbiter of what the Constitution means. Now, at the time that the court made that decision in 1803, 15 years after the ratification of the Constitution, there were still people alive. I think wasn't Madison a signatory to the Constitution? The Madison of Madison v. Marbury, or Marbury v. Madison, wasn't he a signatory? I think he was. I may be wrong. But anyway, my point is that the court understands, and the court has the power, and it is the court's determination of what the Constitution means that is controlling. His next step was, well, how many bar member attorneys or bar licensed attorneys were there when the Constitution was, I think he said written, but I think he meant ratified, because that's when it mattered. And I don't know, and he doesn't know. To the best of my knowledge, there's no census on how many bar licensed attorneys there were. But the first bar exam was given in the U.S. in the colonies in 1738, 50 years before the Constitution was ratified. So how many bar licensed attorneys were there? I don't know. Other colonies fairly quickly after started doing it. Once you have people coming out of apprenticeships, because back then it was apprenticeships, to practice law in the colonies, they weren't necessarily getting the same kinds of legal education as they were back in jolly old England. And so they needed a way to weed out the idiots like Two Truth for Liberty and Rogue Nation. So there you go. There are my sovereign citizen tales for the day. I may return to some, there's a couple arrests yesterday. Tucson police suck. And Slinky, a disbarred lawyer who was disbarred for lying under oath, but I think it was lying under oath. It was about his mom driving drunk, getting his mom injured, etc., etc. Anyway, yeah, so there were a couple arrests. I may do a video on them, but it's the same bullshit I already covered. You can't film in court if there's laws against filming, or if the court does not allow filming in the courtroom or the courthouse, then there you go. So, I mean, it's old ground, but I may tread over it again, because apparently some people still haven't figured it out, including old, drunk, stoner, disbarred lawyers. They may also have not figured it out. Anyway, thank you for watching. Have a great day.